Law, Civil Litigation, Ghanaian Customary Law, Commissioner of Oath,
long residence and human rights applications outside the immigration rules. Don't wait till last minute. Wismart Solicitors. For enquiries, call 02080 165 384. Mobile 07946 772 439. Call our 24/7 line on 07931 411 042. Address 8 to 9 Print House, 18 to 22 Ashwin Street, Dalston, E8 3DL. Overground stations are Dalston Junction or Dalston Kingsland. For buses, 67, 76, 149, 242 and 243. Wismart Solicitors. For how be dying. Now be unse. Ahinifuchiniye ebidi de biye.
Atrema kasa dodo emfashema erade kaso na manu imase
Ghana for wa brotre ha ya te dene yenya emranimfo a won akwadare wo emranimu a poto kasa mu ye kasa a lawyer for entimi nuanom mumyemfo ye immigration ensem nyina enko dan wo mo Wismart Solicitors emranimu akukudrofo se watena ha che ombeboa wo ma wonsa ka won krata na se wedi edro nso a eyo mokokokra eba ne nipa setena mu ani adwuma mu nsem bia omudimu akotene pa omu wo mre di mani pa bia Wismart Solicitors
always puts our clients' needs first. We specialize in all UK visa applications, detention and deportation cases, student and work points-based work permit applications from both UK and abroad.
Wismart Solicitors also dealt with
Immigration Law, Family Law, Employment Law, Civil Litigation, Ghanaian Customary Law, Commissioner of Oath,
long residence and human rights applications outside the immigration rules. Don't wait till last minute. Wismart Solicitors. For enquiries, call 02080 165 384. Mobile 07946 772 439. Call our 24/7 line on 07931 411 042. Address 8 to 9 Print House, 18 to 22 Ashwin Street, Dalston, E8 3DL. Overground stations are Dalston Junction or Dalston Kingsland. For buses, 67, 76, 149, 242 and 243. Wismart Solicitors. For how be dying. Now be unse. Ahinifuchiniye ebidi de biye.
Alrighty, Yamamuna ha ewi Hot Digital Online UK na utie meaning lawyer Nanamwa of Wise Smart Solicitors. Lawyer for a bano pempenso se yankrata sem yatibia iwomu ewo UK abontenso na meaning lawyer Nanamwa of Wise Smart Solicitors ebeshemu ewo fidemu ha ewi nti yade na poso na enso ebro. Wise Smart Solicitors were the 18 to 22 Ashwing Street, Dalston, London, EA 3DL 0208 0165384 0208 0165384 and 077 375 72905 077 375 72905 into Wise Smart Solicitors. Lawyer Nanamwa ewo fidemu a enche obetene nka na yede na poso nyina bretifo ne eye the 9th of November 2024 enti yebehwe nsema ne nsakraye bebre wo ho na yahwe employment se before we jumem na we yiwedi ebra ensene mfata like I say wa abuse right eden na wo ye yiwedi na hwan ne betumi eklemu say yiwedi na tribunal na claims bi wo ha kwan be na beso so claimu wo that to me no edenti ene yiwedi ni na no me ne lawyer na namwa wa ha yebedi nkomo enti Wise Smart Solicitors ena utie ewie yemfa nwumi ntwem na yensambra na yemfa na poso na brete fa no pe Wise Smart ena utie yentie nwumi ye ba na ya to aso. All right. Okay. All right. Mami mo akwaba. Now what is it?
Yesu adom ho ye.
Bibia woko.
Yesu adom bibia woko.
All right. Na pay etwemi den na esi ye wo edwumem na hihye nso aba na wo UK abonten so bia na hihye bia ba enti na yeko.
Yo, me da say now the Facebook no me da say dey kind no me pesa me fast akwan so e de nyame ase e wo ambabo ni sorry mbobro ho a onam ne ba Yesu Kristo so de adom yen ye da na ase gidi se obekoso ade ne do a eni ewie no ekura ye misa e di ase da eni ka bia nso ema adofo no ne ebusuafo a emprempre wo hwe yen won so wo tie yen nyina no echi obia me di nchi akase fi Wise Smart Solicitors a ye pehin wisdom akaho oda no ye di nchi afro nyina ebra mu nyina bibia wisdom enso ne entire staff enso obia enso no echi obi nyina lawyer Francis bibia obia no michia o bigidi so obia eho eye ena wonso michia onso yo yo na obisa question say na watchi nyame bebre ekoso wa we need to the whole world no the country has spoken michia US nyame timi ya dinyina bebi a nipa adwen nko no nyame de ho no obo na ne nneoma wo nyame adwen mu nhihye mu no ena US citizenry enyina so aya adwen ba ko se omato aba ama ye papa Donald Trump ema nkudumdin so aba yeda nyame asese abepto samre yenti basabasa ye bi as compared to the last 5 years ye he no ono kwa na ye hia obi a kire na adwen nti bebi akobia na yafa ne sa ye mame Harris nso agiatum sampa aba no US ma ato ama Donald Trump ndi eya asempa onu say Putin so afre na adana say Wadana also were you ready for negotiation. So we believe say all these kind of things in terms of the war na baba na adin na ano betwa. That's the only thing we waiting for. Okay. Na oba UK hanso a nyama so ekozakra kakra eba na mpese ma two updates for employment home. Okay. So say flexible working pattern. Say flexible working pattern. So wo edwuma mu a na bibinti ebi a childcare needs. Ana say edwuma na wo ye no untimi ye full time. Ana say bibinti na say working pattern esa ultimate sisa no sa na emra no ma nkwa say esa anka ultimate tena edwuma no for number of years bi wo ha 6 months ebi wo ha 2 years and sana you qualify for flexible working pattern. Okay. So say emra no employment law na asesa. Emma you share say you can request for flexible working pattern from first day in the employment. Enti no idea adepa a me say just say o ye fa wa edwuma mu a na say because of mofrahwe anase bibinti na hours no ana time na wode ama no ana say contract na wode ama no emwawa emre wo ho mra no ma won kwan say obetumi a request for flexible working pattern. You don't need to wait and work for number of months or years and so now you are eligible for that. Okay. But the new law no just say unya no you can start make that request. Okay. Until adofo no enhye no so I think say we so beboa ma single parents and your friend couples so they have childcare needs in so to balance their lifestyle. Okay. Very very important. In when we say your national minimum wage, as you say, 21 and above, almost 11 pounds, 44 pounds per hour. Zakraya and so aba on one atum a bit take effect from 1st April 2025. 1st April 2025. And obibia oye juma na wenya 21 and above no from 1st April 2025 no your minimum wage per hour no is going to be increased from 11 pounds 44 pence to 12 pounds 21 pence per hour. Ninya per hour. Ina uyo bi so your age is between 18 to 20 no so no na me no ka say 8 pounds 60 from 1st April 2025 no is going to be 10 pounds per hour. Okay. 10 pounds per hour. Ina uyo bi so between you are under 18, in this case 16 to 17 no omonso no CC America say hourly rating, minimum hourly rating is £6.40. Okay. From 1st April 2025 no, is going to be £7.55 pence per hour. In obi so a oye apprenticeship and also usun apprenticeship no apprentice no also odie no enso increase from £6.40 to £7.55 pence per hour. Enti we na mbese mede there's a difference between UK living wage and the London living wage.
UK living wage.
Yes.
And London
yes.
Living wage.
Yes. Who say there was national minimum wage. A national minimum wage. Okay. Yes. In a year war UK living wage. In a year some war London living wage. Okay. And you know normally London living wage a higher. And see as I'm speaking a 13 pounds 85 pence per hour. And also. And the no year one more London a juma and I don't know and that's it. Until one day no But the basically general one a national minimum wage. I know na mabubo so no. And you know, we hope say from next year February no kono. I think say 4 months to come or 5 months to come no, our salary will be increased.
Okay.
Per the increment.
£12.21.
Yes, £12.21 no. Eye near one increase.
No increase.
First na £11 as of now I make us £11.44.
Okay.
But from 1st April 2025 next year it's going to be £12. It's going to be £12.21. £12.21 per hour. Right.
All right. The lawyer and Namwa and Menini Komoy, Wiseman solicitors, and then they will share the employment law. Send your OT Sefa. Oh, be being so to me, a friend. Na Odi Atuja. Now to me, a friend was 07908443338. Before that, you so back ya. Now you can't a year e-visa no sense. Like I said, this year, and a e-visa no, it will be taking introspection. Na wa utie mi na bia wo sa ha no na no wo passport anaka no e wo viet anasa viet ene de keka hu na no nsakrae ba enti no time limit nsensem no lawyer na namo a obetumi afa no bisa on 079084433338 0208123620 mamu na akwa babio lawyer ye hwe on the ground sir e ban on employment law na wenye dwuma bi na bia yeyi wedi bia dwuma a wo ye no bibia ba me yeyi wedi ayaya wonti ase enti e ka say on the grounds no what can employer dismiss obegina so dismiss an employee then pa no obegina so de yi obi a ono oye dwuma ra ebe yi obi a oye dwuma a fa na employee kwan ben no be fa so a obeyi nedi na say yen fele say oyi nedi a ne kwan so anu no ana say denti and we yi nedi.
Okay, me da say yeah, before I be who say we are talking about dismissal and being unfair or fair dismissal. Before that, you know, let's look at who is an employee. We know the employer who employs someone to work in anticipating to get a benefit, right? Now, so who in the law, no, who is employee? So when you look at section 230, section 230, section 30 of Employment Rights Act 1996, it defines who is employee, right? So section 230 of Employment Rights Act 1996 says that employee is somebody who has or has had a contract of service. So if you have or has had a contract of service by the application of Employment Act 1996, you are being classified as an employee. Right.
You have been employed by an employer.
Yes, you are being classified as an employee.
That is Act 1996.
Yes, 1996. Employment Rights Act 1996. Now, if you have a completed 2 years continuity of service, you have legal right not to be unfairly dismissed.
Okay.
Under the employment law. If you have if you have completed 2 years continuity of service, in this case we are talking about employment of service, you have the legal right not to be unfairly dismissed under the employment law. And the MPSA said, 1 year juma continuously for 2 years. Epo ho ban say ense say wodwuma wura no otimi yi wedi anyhow bia
for 2 years.
For 2 years. Now we have identified say you are employer, you are employee because you are somebody who has a contract of employment. So that make you employee.
The banks.
Yes. 2, if you have completed 2 years continuity of service, you have a legal right to be unfairly dismissed, not to be unfairly dismissed.
Not be unfairly, okay.
Yes, right. Unless the employer can show or demonstrate some reasons which make it potentially fair dismissal.
Okay.
Until employer be ntimi sorry ana say kwadwo meyi wedi. Debi. Employer be ntimi sorry no nka say meyi wedi.
Okay.
Because me na adwuma no eye media. Enti meyi wedi. Emra no so far as away adwuma for 2 years no de emra no ma wo kwan say ebo ho ban say employer ntimi yi wedi anyhow bia. Na mo say employer na betimi yi wedi according to Immigration Rights Act section 98 no e kire say as I say employer no e demonstrate some reasons and grounds e ogina so say ono na order ye so to me meet and also demonstrate that grounds in there then that grounds become fairly dismissed.
Okay.
Dismissal. So you should not be unfairly dismissed, but you can be fairly dismissed based on the grounds that the employer can demonstrate. Now, back to your question, the grounds are employer can will. A dismissal is potential fair if it relates to one capability. Under section 98 subsection 2A.
Okay.
Capability no relating to qualification, it relates to skills, it relates to health, poor performance and incompetence.
Okay.
So say employer say uye adwuma na say ebia ye menfa what about where you fat. So now we are in digital era, right? So adwuma na wo yes say as a DJ no you need special skills to match the current era na
the digital system.
That's it. Until why adwuma now so who needs skills. Until who needs skills no employer no betimi terminate wo appointment and so betimi eyiwedi based on capability.
Okay. So that's another one ground.
That's the one ground. Now capability no also other say performance. Who performance no eduma na eri ama no yehwe ni say mpuntum beba. Na to mpuntum ma.
So no renya grounds no.
It's also for an capability.
Okay.
Into which man say who performance na emwa. Most of the working places, especially when you go to the retail sectors now and other employments, and they set a target for everybody to achieve, and that is good because everything that you want to do, you must focus on a target that you want to set. If you don't set a target for yourself, you lose.
Okay.
Until ABA one set a target, say ABA at the end of the day, as I say, ultimately a complete and also attend to ABA number of customers, and also you have to achieve this one. Now so tell me no ABA the whole day no back all the days ni na a telephone in our way. And in this case, in the minds of the employer, no, or classify say your performance is below standard.
Okay.
And in this case, no bet me ejina so I then eyiwedi. All for capability.
So that one is fair.
That one is fair. If it can demonstrate. It's not just saying you have to demonstrate, and there's a procedure to go by. Right? And another, it can be a health issue. Now, so all of a sudden, no, because of nipeduano, sena aye we conditions, nipeduana back from Uyare, I say, a bit you might be disabled.
To affect productivity.
If productivity. What may fear, I feel now, so called to me, it will affect productivity. And in this case, the pan is not just say, employer and a bit major say, we dismiss you based on capability.
Which force?
Which is fair dismissal. Right. In a kind qualification, if you are no. Ukra basic qualification in our way. What they are ache. edwuma no so kwa yenim ese so obi a timi update no ese o timi ko for da ye induction training bia kra o so me de baby metifie di ya and also customers are no we need to update our knowledge. Yes, we need to update our knowledge na then. And so the yes are that na push bia on bit me gina so say your qualification now doesn't matches the demand of the work. For that matter no bit me gina so dismiss you and capability, which is fair. Okay. That is one. Now, another section 98(2)(b), employer can also terminate your contract or fairly dismiss you based on conduct. Usubain. So, conduct one, either refuse to obey a lawful order and reasonable instructions. So, as an employee, we take instructions and orders from employers. Right? So, juma now employer and as a supervisor, amount instructions. And as you say, no one follow. Now, so the pa now say na see ya na ye no de bia. In the other now about him say yes. Okay. What I say? Quite recently, during the COVID time, in a it should be a popular app. Our client be a men and not a chat. COVID time, yes, will be answer mass. What I say? Now, so distance yourself from where client I do much almost 10 years into a few say or no comfortable zone. Into your okay issue. Into mass nurse audition no the about tie and I no your banner on banner man one is a minua. I didn't say anything, just say Besobiti, she in front of him. Based on that, no, almost terminating the contract. One tia say, a job I mean needing common so no, your conduct, you refuse to obey lawful order and reasonable instructions.
Okay.
One tia say,
that's one said.
That's it. Because you take instruction from the employer. Also, yes, say also yes. It is fair. You didn't obey the instruction.
Gross misconduct.
It's not gross misconduct. This is not gross misconduct. It can be misconduct, but there's a difference between gross misconduct and misconduct. That's it.
So this one, like I said, you disrespect the rules of the contract.
That's it.
Okay.
Gross misconduct, instant dismissal.
Okay. Yeah.
But what I said. And now say drunkenness. Obi a obosa.
Obi a time.
Onumsa. Enukwa edwuma mu. Udu edwuma mu na good morning na obi esi ne hwene. Kofi akobro aba. Kofi anase line type. No afa ye fe na test wechi ho. No akotwa bi. Na odi be didi. Udidi wi ara start edwuma. Oye sa na. Omuhu a. Ometimi ayede. Employer no betimi ayi wedi based on your conduct. Announce sexual harassment. Sexual harassment.
At the workplace.
Say,
be a man.
Be money be who's that? Come. I go the edi. But you have a limit.
Yeah.
A particular place you don't allow your hand to touch.
Okay.
Any any part of our bar, no feel say.
Sexual harassment.
Or more to me say yes, it can classify as a sexual harassment. And now setting like hey, why if you hey, next year, why you say you verbal abuse? No, say I say who enticing, but not in that point. You are doing something to not doing. It can also claim as a sexual abuse.
There are so many things.
There's so many. You can test Obano. Hey, Nancy, dear, we short time. What are you trying to say?
Okay.
What you are saying? It is something so whom sir.
What would you say?
That's it. This is classified as sexual harassment. No. Yeah, consensual. If it is consensual, we would have reported it.
Sure.
Until you can also be dismissed based on conduct.
Okay.
And also misconduct. I stated said there's a difference between
with gross
conduct and misconduct.
Okay.
Right.
So there's a disparity.
Yes.
Between the two.
And that's a negligence or any other criminal offense.
So if in
So
case you
misconduct can be like yen can't say phone yen use phone with you. Now so tell me no sada phone no so sa na we use.
that is prohibition.
Yes.
And you are doing that.
You are doing that.
Disrespecting the
So the way,
company's rules.
yes. Omen no beka sa one far. And I say negligent. Negligent can be in the AP and the working the health and care sector. I say you have to attend to a needs of a service user.
Okay.
Now service user any demand is needs. Now when neglecting now kwaya the fufro.
Okay.
You can be your friend dismissed and a conduct.
Okay.
That is two.
Okay.
In a employer can also dismiss you fairly based on redundancy.
In case maybe the company is going down.
That's right. Under section 98 to subsection C. Now, so redundancy, employer can terminate your employment or dismiss you fairly based on redundancy. One, either the closure of the business as a whole. In this case, for instance, ejuma na yeye wa ha Hot FM no ahunko hia say ye krosu. In this case no employer no obetimi terminate wo appointment because ejuma no ya there ye krosu. Mrano man kwan. Ana say closure of the working place. Ebetimi asa won say first na mo ni ha o.
Na
mo wo baby foforo. Enti baby foforo no mo tu afi ho. Ye de mo aba. Ye hwe ade na ha na ye de mama wo hyanko say obetimi aba ha because nkrofo bi wo ha obetimi aye. Enti because of one close from that place. Enti ebetimi terminate mo. Ana say yemfa say your friend Costco. Ana Morrison. Okay. Ana Tesco. Ebia Tesco operate wo your friend the Grace SS. E ho na wo ye adwuma. Say a hot branch na ya den ya close. Say hot branch dey close so even though Tesco or more your friend other branches but a hot branch here close so you think so mo nyina ma Stratford branch.
There is a redundancy.
And the redundancy will come in. And you betimi terminate your contract based on
grounds.
These are the fair grounds, sir. You betimi aye amawa ubewu say afei no you terminate we no. Yes. And now say reduction in the need of employees.
Okay.
Reduction in the need of employees. Maybe mo ye 100 in a move jumenu. Now when we look at the profit margin, when we look at the customers in your money man, your man air coffee. And answer first because of the manpower and you person you probably ever say we've introduced something called digitalization. Digital. To say home office this year a lot of border force are with the airport we be call redundancy because they won't need them.
First one is physical.
Yeah, physical. My share. They won't need them.
I don't think say and also will bring a year serious unemployment in the system.
You see, you're supposed not to be unfairly dismissed unless on this grounds.
On these grounds, okay.
So first, before you dismiss somebody, you have to identify which particular grounds are who you should now the employment law no say you must follow a certain procedure.
Demonstration.
That's it. Into only pan fan say ye visa ye nkrofo bebre be affect wo. Into physically won't mean you border force checking. Into who you ready. You don't need to only immediately say who you ready. There should be negotiation, consultation. Some way you call digitalization. Into munipa 100 ye hia munipa nyia. Never be hia nipa 40. So there's a process going by it. No have checking to be about it. You have to get consultation. No business say in your mind no me if you have is there any other way between the na akoto ho obetumi akoha.
So that
So you
comes
have
under negotiation.
that's it. You have to look at all these things, and finally, and someone say you don't have any other way out apart from say uyinedi, and that one will be an redundancy.
Okay, which is fair.
Which is fair. That will be. And now to you can also terminate someone in order not to break the law.
Break the law. Okay.
So let's see example like wafobi na oye ejuma in the course of work now nipa ko ne ejuma the visa dey
Nipa na wafana.
nipa na afana employee
Visa during the time
oye ejuma as I say the visa bia no 10 year ko renew but this time no ewu ontimi an ko renew into wabayi overstay Imranso chess kwan say you should not employ who has no right to work.
Okay, that is overstay.
Yes, but when you parents or ye juma or ye bibia fine. A cowpedia and come on Paco natural so because when Paco started ye juma more than 10 years. Ache. That's it. But you don't want to break the law.
Because
so when you break the law, you also be penalized. By fine. They say no, it's almost 45,000 pounds per head. That's it. Into what nipa miensa, what will you do? Ube dismiss. So you can also base on the grounds because I don't want to break the law. Therefore, I'm going to dismiss you. Which is fair. When we are able to demonstrate all these things, then we say that your dismissal is potentially fair.
Okay.
Right? So these are the grounds, 5 grounds, and ultimately also say, and so cannot just because of misunderstanding one and no term personal no. You cannot do that. You cannot do that. So that is that. So it can also be like a clash of personality. Employees too. Now they be more personality. More clash. Where's the minimum sound? Where's the say? Where's the say? No. On no bet me na so ma. You were in Crawford.
I know under the capability
No.
Because they have 5 sectors.
No, under the substantial reasons.
Okay.
Substantial reasons under section 98, subsection 1B.
Okay.
Personality clash. Go baby or do a juma on wait to me and ye juma on a clash personality. Now on why make Koskun say oh me say they be a crash. So you can't see the teamwork there.
Okay.
So it's a big creative problem there. And you pay you that's it.
Which even when you go to tribunal to seek for a claimer, it will not work because you violated the laws of the company. You will think that you have been treated unfairly, you have been dismissed unfairly. So you want to go to tribunal to seek clarity, and then maybe a compensation should be awarded to you. How then those?
Yes. So there are certain procedures in which you have to follow if you think your dismissal is unfair.
Unfair. Okay.
If you think your their dismissal is unfair.
It's conditional.
Yes, if you think that your dismissal is unfair, there are procedures. You cannot just go straight to tribunal, employment tribunal. No, you go straight to the employment tribunal. They'll strike your claim to the bin. The procedure, you have to go to ECAS. I think so. Be fair, but to go to ECAS first.
Okay, ECAS.
Yes.
Yeah.
And the negotiation will be there.
Yes. Okay, next, hello.
Yeah, Kobo.
Nasrene.
Yeah, Kobo Patwan. But what is a lawyer man? What is a
yes, I don't know your part.
Lawyer man always says supervisor who on powers of bet my you would anytime be obia. No one who can Obu we are Juma Pa about Buffer Port, especially cleaners. Obi Yajuma was you why you say what in the fort. And I think say unfair dismissal idea. Uber Grandpa. You bet my over found what me you would. Okay, my question so. Me what problem me Obroni Baby, there be I know how game what film up from. Me person me didn't cause sexual harassment, but you bet my sir.
Who's Obroni Banner yet day?
Often.
I have or game. I am where me. Oh, I am a sad me person, Miss Wonse, Miss Mia Sofu. Me can't want to me person me didn't corner Kayin, this come me, me patronate my sa. Give me Mimpa, Debia, or ya name way in the tea, who said, and I'm so for me anything. Mimpesa, Debia, and patronate me in a cocoa. I'm in the Diamond.
That's a fatos the answer. That's a pretty baby. I've been from a man who I kissy. Say to grow. Or you are so food. Trespass. And you wait me in the NAPO for sexual harassment. There are some internal procedure as an employee. When certain things happen, you have to follow. First and foremost, one casano. What you ask yourself, what relationship do you have with that particular colleague? Okay. You have to look at it. What relationship do you have to have? A idea, a grow up, they be a moody. Or not a one off. And also, it you know, all can all the buffy one. Also, who you then I'll catch them. I'll catch them some person, and I'll smile back. If you smile back, that means when you have your the next time will continue. But if you are saying, so, Kojo, I don't want this because I'm a priest, me also so I don't want it. Now next time, you report to your manager, and there will be investigation.
On report to you.
On report to you, also no who you need compensation. That's it. So, and there are certain reasons there are certain reasons they are categorized as being automatically unfair. Okay. Reasons now ya can. Okay.
Congo.
Yeah, but one year.
Wow, it's
Boko, one I say.
It's your lawyer, coach.
Coach, you.
Person this a question. The patcho say you are dismissal. How long do you have? I mean, and I was the time limit and so I wait me appeal or not appeal like say you take them on for unlawful dismissal. How long do you have? And secondly, say can I say the same dismissal, no? Say, my friend is on the grounds of ADI. For example, you say, off sick 3 times in a year. Now we are genuinely 3 times. What doctors report to prove it. Now, so do you have grounds to? Do you have grounds to appeal the decision and I say take them to court? Okay. These are my 2 questions. How long you have to do it? I put in a question the grammar and say, I'm just how long do you have? Yeah, 2 months. Okay, we have doctors say you to prove okay. And how long so now?
How long do you have to litigate the matter in tribunal?
Exactly. Okay. Exactly.
Lawyer, coach, you have valid questions for dismissal or for unfair dismissal. Lawyer, let me say 2 questions will decide.
Yes. So one question, is subject to mandatory early conciliation process. That is ACAS. Ultimately, all of us say na me make ultimately call tribunal straightforward. Okay. Yeah, but you have 3 months.
3 months
within which the incident happened. You can lodge the complaint.
Oh, okay.
So imrano mahun kwan say wo employment law na ACAS code of conduct. Okay. A man kwan say any employee wishing to make an employment claim must first engage in ACAS early conciliation process before bringing the claim.
Okay.
So the employee cannot bring a claim to employment tribunal without an early conciliation certificate from ACAS. So ACAS your friend a podia adversary consideration aberration service. Okay. Wojinamu as mediators.
Okay.
And they say bibini bana first we have to go to them.
The ACAS.
ACAS, no, we report to them. And they will come and mediate.
An advisory board.
That's it.
Okay.
They will come to mediate. Now, what issue now? What they about? They will write to the employer and say now, employee no,
What do you do?
Against you. Inti be you are no. Into bad they will try.
The ACAS, no. Where do you? How can you locate them? You go.
Oh, if you go to.
You have their numbers already.
Yes, if you go to Google. You go to Google. Google. And type ACAS, ACAS. ACAS.
Okay, so ACAS.
ACAS.
Okay.
Wow. And you know, Okobo wa man yes say this here. ACAS be jina wa name no invite employer no. Say na employee no abeka. Enti wo anu yi a. The motive and objective say o stretch o meka asem no e wo kukuemu. Na ne ye atu ye. Sa na employment law no e ma ho kwan. Enti eba na sa na that 3 months no you put on stop.
Okay.
That 3 months they put on stop and the time ACAS no ebe sorto ebie. Say ACAS no sorto na mo mienu nyina ma ante ase a ACAS be ma mo certificate. Edi adan say wo de asa no aba wani.
Okay.
Na afi no
so right to the employee.
Yes.
The employer.
Yes.
Okay.
Enti no o ma mo certificate a na afi wo gina sa certificate no eso na afi wako employment tribunal.
Okay.
No wako your claim no.
Okay.
Ebetimi aba say obeti ase employer na enti ase at the same time employer ACAS memo certificate ebetimi aba say employer na ati ase na wo employee ni wan ti ase enti ebe mo say mo bienu nyina mo ti ase se afi ne anamo ACAS dey ato no aye we are that the case end there.
Okay.
So you have that 3 months but the 3 month pause when you engage with ACAS. After ACAS, then your friend 3 months start again.
Okay.
So you have 3 months. So ultimately, now the second question, actually say, why yare 2 or 3 times minimum law? What can say we yare? No, I can say, and this is we yare more than 2 times a year or sometimes. I don't know because sickness you cannot predict.
You cannot predict. Okay.
Unim da oba yare.
But he was speaking, say he has a record from the GP. Said he was indisposed. So he went for a report so that report could be rendered to the company. The company is having a doubt of his ailment now.
Yes.
But they will still insist they want to put you on hold or they want to.
Yes, so normally,
I think that is where
normally when you are sick, now you get a report from the medical professions. Explain your health issues.
Okay.
Some of the illness in a long term. Some of them is no just want me and starting in your human view. And you know
that is obey incapacitated.
Yes.
Okay.
Into a banner sana employer no they be every 3 months they will assess you. I can say which me aye.
Sure.
Jumano anasontie. Say koba say the nature of work no want me ye jumana. Then the employer may not have any other alternative than to dismiss you under capability.
Okay.
Under capability, which for an health issue.
Health issue. Okay.
Ebi wo ho na ni nyina depend the nature of the work no. Ebi wo ho na wo yare no ebi a untimi nyina ho enche. Nti no betimi abase betimi apɛ baby adjustment. Mrano ma ho kwan say they should do some adjustment. Betimi abase wo de over better recession when receive customers.
Yeah.
And now certain job will be it doesn't need much physical way obetimi aye.
Because they are digitalization.
That's it. Ebetimi ben so as say enam say we have issue to untimi be adwuma nso no we provisions that and ebetimi aye adwuma no wo bejo adwuma no online
Okay.
e wo fi a obetimi aye but ye hwe ni nyina na say they don't have that way now then the employer doesn't have any other alternative than to dismiss you under capability.
Okay, yes, hello.
Yeah, but sorry, me and you.
Oh, coach. Okay.
Yes, Papa. Okay, maybe some you see almost company policy in the say, we are absent 3 times in a year, subject to disciplinary.
Okay.
Now, no, yare, Nina, no, yare, 3 times within a 1 year. No.
1 year.
Nino, yare, more the hospital, the coach, doctors report the coach, but almost say whether yare 1 year, company police in the say, almost say you cannot be absent for 3 times within a year. It's 3 times now, yare, even though the way by, the story doesn't matter. Omo police in the chair say, oh yes sir, the subject to discipline. And no more general to the unity.
And to me unity.
And to my unity, yeah. It's no officer say or beat me up because even though that's what the police say, but he was genuinely sick. Our doctors report.
Yeah, men who points now, yes. Men who points now, yeah, fair now, yes, or generally sick. I do appreciate it. We don't.
But
the company doesn't only depend on its policy to dismiss employee. So the policy and the employment law must go hand in hand. If you look at the contract of the new way, what does it say? Because some of the policies, it doesn't comply with the employment law.
Okay.
So we have to look at it. In a case, so generally, only 3 times a week. That's fine. Does it mean that ne yare one entimi manu to eduma no so biomana? That's another thing.
I mean,
yes, and so to me yeah,
normal one.
Yeah, that's what I'm saying. So to me yeah, because ansana employer no begina so say when you were because o yare no na just say o yare one it's going to be permanent. There's no any alternative bia. Yeah, the old chair, yeah, cast a traffic online, untimi yet. And as you do, baby beer, no, untimi yet. Before that, it is because why are they 3 times? And intino, you were dear. That is totally wrong.
Okay.
That is totally wrong.
Now, we say no.
How long no one son with me appeal patch of his son?
So
because it's been 3 months already.
Yes, he has one. So tribunal now. You have 3 months within which you have to make it, but you have to first engage with the ACAS first.
The ACAS first, okay.
Right.
I don't know also ACAS for.
Say person
mama imagine the number or mama na fro na.
Yeah. Say person
no problem.
Okay, all right.
So one person will call ACAS. You have also 6 years within which you can lodge it.
6 months.
6 years.
6 years.
To court. There's a tribunal court. There's a tribunal.
Employment tribunal.
Yes.
Employment.
Then other high court or court.
Okay.
High court and as a court no, 6 years.
6 years.
But tribunal no,
3 months.
3 months.
Okay.
But you have to engage with the ACAS first.
Before.
When you start engagement with the ACAS, the counting will it pause. 3 months no pause.
Okay.
After ACAS, then they will start 3 months again. And you know, engage with the ACAS, and the ACAS will invite the employer. Then they will sit down, they will negotiate it. If it happens, employer na and year, ACAS will issue a certificate. Say what by your heart. You based on the certificate, then you go for claim in tribunal. But ask yourself
compensation
for compensation. But first you have to ask yourself whether you are employee or you are a worker.
You are a worker. Okay, that one too is another.
That's because if you are not employee, you cannot make a employment tribunal claim.
Okay.
So there are certain things that
and here comes where somebody should be working with the company for 2 years.
Yes.
That 2 years is mandatory
yes.
for claims when you have been dismissed.
Yes.
Now, under the law, in the Act, it talks about employment in 1996 Act.
Yes.
They have something we call Equality Act that comes in. So if somebody has worked even less than 2 years and the person has been dismissed unfairly, you can still make a claim.
Now, according to Section 230.
230, okay.
230, it defines who is employee.
Who is employee?
So we assume say Unpakuno a employee because the person has a contract of service with the employer. Now, regard to the period, okay, section 108, subsection 1, it defines that if you are employed, if the the contract of service starts on or after 6 April 2012 now, if your contract starts on or after 6th of April 2012 then period of service must be 2 years.
Must be 2 years, okay.
The period of service must be 2 years. So contract must start on or after 6th of April 2012. Now, before you can make a claim, not just say 2 years, which is why you do for 2 years.
For 2 years, okay.
Now, say who started, who contract must start before 6th of April 2012, and they also demonstrate why you do for 1 year.
Okay. Okay.
Therefore, if it is below 1 year, dear, not just say you cannot be entitled to your you cannot go to tribunal for claim because you haven't met the continuity period.
No, this one talks about a scenario.
That's it. You haven't meet the continuity. That's why health and care. What do you want do rough? Because on your past 6 months, and 3 months, you wait.
Okay.
And there are certain category of dismissal by employment law. It's classified as automatic unfair dismissal.
Yeah.
I say if the dismissal relating to pregnancy. Say be on the pakuna yare or him. Quite recently, in beer, health and care, or in Nikun nearby. And I'm say, and you say, by why you man for more 5 months. Unpakuna, they say, or bano, one channel also into 1 year into a year, and you automatically your friend unfair dismissal. Settings automatically. And now, if the dismissal related to a childbirth, and now health and safety. Health and safety say health and safety they were hono I can't relate na me ko kan say na aha me my year no you prepare here condition you prepare and it wey it's against yes it is automatically unfair. It doesn't matter for the 2 years and now 1 year. No, it doesn't matter for the 2 years or 1 year. And now say if the dismissal relating to whistleblower, somebody who can inform or tell the company about the indiscriminate act about what is going on, which is against the law now.
Whistleblower act, blind eye
yes,
on what is happening. The activity that is happening that is harmful to the people. You are not protecting their interests. So the person can be a whistleblower.
Yes,
he can lodge a complaint against you.
So
like, that is like an expert motion.
That's it. So whistleblower act a protective. Into no say not because of near echo some makoka. Now we're acting, no way according to Employment Immigration Act. My dismissal automatically unfair. Or no, and chase a many 1 day and not 2 days and not 1 year crowd with Jumamukra. It doesn't matter. It doesn't matter. Health and care for no baby or honor because duration nature says so near 2 years. In a 1 year, anything. If you was 6 months, near Unity. Obi or now or ban or fire fun. Obi to make business. I don't know for your fun time. I don't know since we understand it. But what you man should not prevent me to enjoy my private life. Because besides that, so come eternity and yet I'll go to your abandoned. So what is your problem? We want to make you have a careful because they haven't served in employment for 2 years for them to be able to go to employment tribunal
or reinstatement.
That's it. Until one for So that's
such person when the person is dismissed, like we are saying, he had 3, 4 months, 5 months in the workplace. Will there not be any way that the lawyer like you can protect the interests of the employee who was unfairly dismissed in court to litigate this matter so that the person can be reinstated?
Yeah, we always take instruction from clients. Whatever the client will instruct us, we use the law and make it.
Okay.
This particular incident, client ne buy me man of all the employment policy ne buy and your friend your employment and the contract no buy there's nothing in the contract as a clause says onyama is you wedding so the employer has breached the Employment Right Act as unfair dismissal. And to me, in this case, say I want to take it on. So I start writing to them to explain to employer to explain the grounds on which say about. Unfortunately, the employer was able to convince the employee, and they were having negotiation behind me. Behind me.
But did the employee alerted you or did he?
No.
One country.
How old are
you lawyer? No lawyer need to get you.
And now
what for the
why
are we consistent?
Your friend employer no at the other say we me film and ya she mesa reinstate you but obeko baby foforo. O Ghana say wa ba foforo. Enti na dwumu no aye ntechi na obaka kem say on pese say the same on pese metu aso no not to there be. Let me continue because I don't know what they are. It is against the employment law. What now we say it is totally wrong. It's totally wrong. It is man on
answer yourself for the employer to convince you.
Most of them for
that's
them sometimes it be in the desperate situation and
I
fear no because certain things or catch an employer and say they no run and you want to pouch out there also be made for the milk until the janenka. And this employer convinced the employee to sign, say, mean discontinue my claim. Now on and negotiate. And all the bad say, where one out there about this also mean you man, and all that, and all the no quiet. Now, one can compare dine war, now me compare be man. La so now one side dismissing said, what do you mean ye man? As an answer. It's your answer, no, I'm sorry, I can't be doing this.
And I go to a occupational hazard.
So these are the things. If you are now, or the Juma of Baha, so now I desperate who started pet, not feature also. Send employer can one share a having or since a teacher. So, see, I'm somebody I like when you start fighting with me, I want us to end.
Yeah.
So that I can learn the lesson. Yeah. That's my nature.
Because I said that the president.
I don't. Me people want say me will be very quiet. But I don't like ACC. I hate it.
Cheating.
I hate it. And when you bring your fighter, we want us to finish the fight. Then we learn something from it. Yes, I say you could see. That's how about it. Nyaminti, nyame bebre wa near buye ni kuso na it go. But whereby it is clear, say you are really taking my leniency to be your advantage here. We have to allow the law to work.
And that is where people
and it will set as a precedent. The next time, that employer no on for because we don't know no more people are use abuse. We need one to sacrifice. Yes, and to sacrifice to get the independence. For Kumasi for.
Okay.
So and sometimes you may be brave because so one for one specific one. You bet me after was a 9 prime officer or yard not the call. Totally wrong. It's totally wrong. So these are the things that I say when something happens, make sure say you allow the law to work.
Okay. So in this case, me afraid or no
obey me aba. Because minimum law be a say.
Now go to the documents be
Oh, it's all about the documents in Ababa. So or the unfair employment policy number employee hand we book no employee hand book no unfair no find the contract and some now we look at it now if you say but if find a one trust say we yare 2 times in the year and as a way now it is a miti payment bosumi no chana so miti payment no chile so miti payment and am nya fru yare every sickness is sickness so many fru January in April no so misanya fru it metimi anko in a deserve my so Messiah another fruit.
Which
now it's a way you
also
made
evidence. Say
yes.
doctor's report.
Yes.
Emma clear indication said I was going through this
Yes.
until you can consider it done. But if you see,
that's one my person on far document number. Near crosses are say if you are sick 3 times a day, what kind of sickness? Me you sick, but meet me a juma. Have you make any provision? Have you look at alternative? Say I sick, I want me you did not have have you invited the person, assess the person? Have you your friend tell the person the effect of this sickness, the impact before you arrive. Okay. So there are a lot of procedure.
Okay, it's not easy.
No. There's a lot of procedures. Another ACAS code of code. About 11 procedures you have to follow. If you breach one, everything becomes unfair dismissal.
Okay. Now that is to the employer.
Yes.
Okay.
Yeah, before employer be dismissal, you have to follow 10 procedures.
10 procedures. Okay, you cannot just.
No. And when you breach one, when you go back to on one.
Okay.
On one. I got another friend dismissal letter be if you make client. If you are any na catch and say what umbra for disciplinary hearing. Or called disciplinary hearing. In a almost say dismissing. And he has right to appeal. What I will follow because the procedure is going to follow. And I'm so okay. You better hear you. Near panel na almost for hearing, dismissal hearing, the same panel in almost transfer for appeal. That is against the law.
You can't do that.
You can't do that. Until
there's a conflict of interest.
Wow, dismiss him. According to the law. According to the law, the next appeal should be a senior man. But in this case, no, they are dismissing on one so na boss. You know what's not caught now. So are you that one to reason say this is the law? This is the law. So you now over dismissing one man appeal. That is correct.
Okay.
One was not trying to pay no so. Then I been a war. And I also say near what can now you are breached. So you are paying with.
You are not going to have a change of mind.
Me pushing. So at the end of it, as I call high a friend, somebody director from another company right to come and sit on that appeal case. Before and yes, I'm saying this is a breach of employment law, and which diminishes the element of your dismissal. Yeah. Because you didn't follow the ACAS code. No. And in this case, me man alternative, and he went outside the jurisdiction and look at somebody, a director who is higher than him in another company, to come and sit on this.
That will also breach the law.
Well, so good things there. A director, because I'll sit here, over there, or appeal, or then sending now, some letter or that, and director fans say the procedure and Kassan company in France say total wrong.
Okay.
In a moreover, say, I only pan now. At the time only pan man, the person is under supervision because only on 6 months probation in way, so he's still under supervision. In a Ujan said one and and an incident happened.
Yeah. So you look at
so you rather break the thing because the person is supposed to be under. In our claim say, oh, be na more of one person one year now under supervision, so there's no supervisor.
Yeah.
Then how do you expect say
probational thing now?
Yes,
they are under probation.
Yes,
so they don't need to work single-handed.
No. Somebody has to supervise them until you finish your probation before they can offer you.
Contrary to the law.
Yeah.
We were breaching.
We were breaching.
Because officer we are naive.
That's it.
A person cannot go to a lawyer to seek for interpretation, like you are saying. A person who is a manager of a rival company that you employ to come and sit in the matter has even directed you like a solicitor Papa na wo kana say he input in that so be a solicitor.
So no we no intention or that advice is no training no na we ade na o ye ne supervisor ka ho anka on court to that extent anka supervisor in a moral balance no or your friend is still under probation or trust so he's still under ultimate guardian say when you need because one year it is totally wrong. So we didn't go further. We negotiate and I think that you pay another branch man because guy needs a son why no feel comfortable working there. So there's another branch
that was posted
or the two so that's what you do.
Okay.
And so it's not just where you need the you look at circumstances and look at the steps whether you follow the steps you follow this. So that's why I'm not me say who you director in the normal circumstances they say who deputy etna hearing so na appeal no what na so and I'm meeting the you go for bebre
but not just say the oil no it is happening.
That's what so face say on face say once why disciplinary no one appeal right in the say or you man fine in the do one for them appeal right but on control say you have to be accompanied with somebody
okay.
Manager say it's not verbally. You have to write to the person say you have a period your fair and hearing. This is the convenient time for the person, and you have a right to accompany with other union member or a friend.
Okay.
And it is this dismissal letter never. Minyata mhweni nyina. It is a want me anka obi also say me catch and say did you write it there? A verbal, I said no. This the dismissal letter. This a friend invitation for appeal. What do you mean? Anka way now? What breaches the code of a friend ECAS. Therefore, this is not valid. Okay. So it's not easy. Our guys also report 1 year waiting or yari 2 times, 3 times the way. Okay. Is there any assessment?
So like what you are saying. Or when pay your free or bar, you scrutinize.
Oh yes, of course.
And then go to the nitty-gritty of the matter, and then see whether there's a potential breach.
Yes. First, I have to look at whether he's employee.
Yeah.
Under section 230 of Employment Rights Act.
Okay.
Whether he's employee. Then I also look at the continuity under section 108.
Oh, 108. Okay.
So, we have found when you're 2 years and answer 1 year.
Okay.
Right. Okay. Then I will look at the employee's manual handle book.
Okay.
Then I will look at the contract way no so. Then look at the courses na ewo. Then we look at the GP report. Is the GP saying said the other one or yara is going to be permanent? Intino onti me yeduma bia. Then you look at the 10 steps, but ECAS says so for procedure and says so for. Did you follow all? If you follow all, was there any consultation with him before you arrive at dismissing the person?
Okay.
So it's not easy.
It's not easy.
And don't think guys policy they say don't me yare 3 times you know. Your friend now to me no 3 times. No, it can't work like that.
Lawyer na namwa na otini kanti enu ya onaro wo frɛ so wonu na yi ne no but what their friend number 077 375 077 375 72905 077 375 72905 Wiseman solicitors meaning lawyer na namwa and then ibetumi edwumedi abro sai bi besa to aso na yet be before swaba because unfair dismissal na koso people who don't have obviously the correct backing na obi ne dia no ayi din no ko unfa or say you medio intimidifie menye adwuma ye there have been a lot of instances that people have been dismissed unfairly until they must be given a fair hearing, especially when they seek an interpretation by going to see a solicitor, so the solicitor can quantify and then also look at the nitty-gritty of Nsemno and some of our head. God lawyer and Nama want to get the documents that propel you, the employer, to the employee and the instances are leading to the dismissal of the adwuma no and won sem and then you dey brown tin and chebe mai musu e boda masi lawyer na mo ada na we catch up for the mai musu
yo ebusuafo yeda mu nyina ase wo pepenso amude nyina abedunu not all the dismissals are fair. Most of times, majority, and fair dismissal, and you have right for compensation if that happens. But unfortunately, employees are maybe some come yen no say. Oma ye jumani we are no. But employment law. When you are employed, you have 2 months within which employer should give you a contract of employment.
It shouldn't be
more than 2 months.
So that in case of any
so that you know what you're supposed to do, what's not your rights and employer's rights and other things.
So that you don't infringe
and employees handbook is very important.
Okay.
You move a prayer, no say nyame adom yenye adwuma ya aka na ya to nti yenya time in ready on no we ready e bo ma hu ni a wo. Do you know say even when an employer sets a target, unreasonable target for you to meet, it is unfair dismissal. You can use that one as unfair dismissal.
In the book.
Yes,
you should read.
And an employer name the behavior and so no ubetimi kura gina so na worries and to a claim. Revocation you fair na when ubetimi gina so because the behavior no ohun a na wa ye bibi na o target na dey bia yare ni mo
I say at random.
That's it. Okay. It is any many na e wo ho eduma na ye no mmra no e support employment law no e support obi bia oye eduma. Enti no say wohwe na say wo supervisor ana so bibia ye fe no manager na ye adwuma na onye a manani bra na ho so say mmra ewo omaimu a ebo ye ho ban na bibia na onti ase a say na wo de telephone number 077375729 which me afra na etimi abo antra say ye fe ne we made man enye hwe me ko hwe foforo da bi unim say obi a wo koye sa na wo be save nkofu bebree ebi odi ye nkofu bebree oyi we di rough enti no da bo nyina ase.
All right, that's papa la na mo a na telenka enti ye ko na ya try be so